You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients. Hello, everybody, and welcome to Wiley Ryan's Political Law Podcast. I'm Rob Walker. I'm of counsel in Wiley Ryan's Election Law and Government Ethics Practice Group. We have talked on this podcast before about the Foreign Agents Registration Act, or FARA, and today we're going to take a further look at some recent developments or potential developments in and surrounding FARA, including taking a look or talking a little bit about a recent ABA task force on FARA, which may jibe with some potential or proposed statutory changes to FARA. And we're going to look at some other policy and compliance considerations in connection with the Foreign Agents Registration Act. Joining me today in the heart of this podcast today are two of Wiley Ryan's top FARA practitioners, Dan Pickard, who is a partner in Wiley's International Trade Group and co-chair of Wiley's National Security Practice and of Wiley's Foreign Corrupt Practices Act and Anti-Corruption Practice. Also joining today is Tessa Capeloto, also a partner in Wiley's International Trade Group. And both Tessa and Dan practice extensively in the FARA field, or to use an alternate pronunciation, they practice in the FARA field. And together they have co-authored Wiley's Foreign Agents Registration Act Handbook. And it has been my great pleasure to work with both of them on FARA-related matters for a number of clients. It's great to have you both here. Welcome, Dan and Tessa.
Thanks, Rob.
So let's get started. Maybe start with the basics. Dan, just simply, what is FARA? And give us some background on it.
Sure. Thanks again, Rob. So maybe just to take 2 or 3 minutes to set the table, FARA is a national security law that was created to increase transparency in regard to foreign actors and their activities affecting perceptions of the American public and decision-making by the United States government. And FARA actually goes back to 1938. It's a law that's been on the books for quite some time. And while the statute might not be drafted exactly along these lines, when talking with clients, we have a tendency of framing it up as 3 issues. That FARA creates a registration obligation with the Department of Justice if 3 boxes are checked. 1, there needs to be a foreign principal, and a foreign principal could be a foreign government or a foreign political party, but it could also be a foreign corporation, it could be a foreign private citizen. So the first box is the existence of a foreign principal. Second is that there's got to be an agent in the United States acting on behalf of that foreign principal. And an agency relationship can be established one of 2 ways. Either the foreign principal is directing, controlling, managing, or supervising the activities of the agent, or in the alternative, is essentially funding the activities in whole or in major part of the agent. And then the third box is that the agent has to be involved in one of 4 covered activities. Those covered activities, broadly described, are political activities, number 1. Number 2 is certain public relations, political consulting, publicity agents services. Number 3 is soliciting or distributing things of value, including money, on behalf of the foreign principal. And the 4th is really just representing the interests of the foreign principal before any agent or official of the U.S. government. So again, just to kind of recap, FARA is a law that requires registration of people acting as an agent of a foreign principal. And an agent of a foreign principal is defined by the existence of a foreign principal, broadly defined, that agent acting within the United States, and that agent being engaged in one of four covered activities. And importantly, FARA is not a licensing statute. It doesn't authorize behaviors per se. It's a registration obligation. It's a requirement for that agent to provide certain publicly available information to the Department of Justice on a periodic basis in regard to providing descriptions of its political or quasi-political activities. Statute is administered by the National Security Division at DOJ, and there are both civil and criminal penalties for violation. Criminal violations can be pretty steep, including fines of up to $250,000 per violation and a term of imprisonment for 5 years. But at its basics, again, just kind of to set the table, FARA is a national security law designed to make sure that the American public and U.S. government decision makers are aware of the activities of foreign principals when they cross over into political or quasi-political activities.
So, Dan, your mention of potential civil or criminal penalties in connection with FARA brings up the fact that there has been really over the past couple of years or few years a great deal of interest and perhaps increasing interest in FARA and FARA enforcement. So, Tessa, what's happening in that area? What's happening with regard to FARA enforcement? What's causing this kind of increased interest, not just among FARA practitioners, but in the news media and more broadly, increased interest about FARA and its enforcement?
Sure, Rob. So, 10 years ago, you mentioned the Foreign Agents Registration Act, FARA, and people look at you and say, what? Wait, what is the name of that statute? Nobody really knew about FARA except people like Dan and I who really practiced in this really niche area. But really, since 2016, and I can talk about the start, we have seen a huge uptick in FARA enforcement activity and huge uptick in attention in the media to FARA. Really, what started all this, some people think it's the Manafort prosecution, which was in the news, in 2017 when he was indicted, but it kind of goes a little bit before that. So in 2016, the Inspector General issued a report on the administration and enforcement of FARA. And the report kind of painted an flattering picture of the enforcement and administration of the statute. They found a lot of deficiencies in terms of registrants not filing on time, registrants not filing at all. They found that the unit enforcing the statute at times was not enforcing it how it should be. The Inspector General report also noted that there's been a really small number of prosecutions in the statute. So in all, the picture that came out of this report is that more needs to be done, more attention on FARA needs to happen, and that people that are acting as foreign agents in the United States need to be complying with the law and following what they're supposed to be doing under FARA. So following that report, we started seeing a slew of different criminal prosecutions. So just to put that in perspective, so between 1966 and 2015, so in that roughly 50-year span, there were 7 criminal prosecutions under FARA. The DOJ website alone right now, shows 10 prosecutions since 2017. So already you see in the 50-year span, right, you had less prosecutions in the last 3 or 4 years. And the website highlights some of these. You have the Manafort prosecution. He was convicted in 2018 of engaging in unregistered work for the government of Ukraine. In 2019, you have Skadden, who entered into a settlement agreement for certain violations of FARA. They were basically acting as public relations agents for the government of Ukraine without registering under the statute. In 2020, you had Elliot Brody pleading guilty to a conspiracy to violate FARA for work that he was doing on behalf of certain Chinese and Malaysian interests. In 2021, you had this individual, his name is Imad Shah Zuberi, who was sentenced to 12 years in prison. Part of that was failing to comply with FARA. He was doing work for the government of Sri Lanka without registering that work as required in the statute. So there's definitely been an increased focus in terms of criminal prosecutions. We're also seeing some really interesting registrations in the last couple of years. There's been some high-profile media registrations, for example. The registration unit has focused more of its attention on the media. You have the registration of RT, of the Chinese news outlet CGTN. There's also been requests of Al Jazeera to register under FARA, although I don't believe to date they've actually registered. So there has definitely been more attention, even beyond just the criminal prosecutions. I think DOJ is taking more of an active role in reaching out to individuals when they feel that there may be a registration obligation, or they get wind that there might be an individual or entity acting as an unregistered foreign agent in the United States. They are proactively reaching out to parties, saying, hey, we saw this in the media, we saw this report, we believe that you should be registered under FARA. Why are you not doing so? So, we've seen a gradual uptick, and I don't see really any end to it, but there's definitely been a lot more activity on the FARA front.
So, notwithstanding that increased enforcement activity, and really, maybe it's better to say because of that increased level of activity, there is and has been recently an increased level of interest in Congress and in the legal community more broadly about revising and reforming FARA. What's happening there? What are, maybe there are too many efforts to talk about fully, but can you give us a sense, Tessa, of what those efforts are and what's going on in that area of FARA reform?
Sure. So the statute is quite old, dates back to 1938, and there has not been a lot of amendments to the statute since its original enactment. So the statute refers to terms and concepts that might be a little bit outdated. So there has been effort through the years to modify the statute, to modify the regulations. In terms of some of the more recent efforts, just last month, the International Law Section of the American Bar Association, they had established a task force to kind of, look into FARA, look into the statute, look into the regulations, see what modifications could be made, what type of guidance could be provided to DOJ to better ensure the, the most efficient and effective administration of and enforcement of the statute. And they came up with a list, I think, a pretty interesting proposals. Some of them would require, a change in the statute. Some of them would just kind of require that the DOJ's FAIR Registration Unit, which oversees kind of the administration, the day-to-day administration of the statute, some of those suggestions are more for the unit, how they can kind of switch things up on their end. In terms of some of the recommendations, one of them, for example, and some of these would require congressional change, but one of them was renaming FARA. The whole concept of a foreign agent, right, is a little bit ominous, and it can have kind of a negative connotation. So one of their proposals is that the whole concept of a foreign agent should be changed because of the stigma, and also because agency, and I think Dan mentioned this, agency under the statute is quite broad. So you can be an agent without really engaging in kind of what is common law agency, right? You can be an agent without having a contract with a foreign principal. You can be an agent without being paid or subsidized by a foreign principal. So, there's that proposal. The task force is also asking that the whole notion of a foreign principal, that be revised to really focus on foreign governments and foreign political parties. As Dan indicated, foreign principal is quite broad, right? It includes foreign corporations and private foreign individuals. So the task force is saying, hey, we really should limit this to foreign governments, foreign political parties. The task force is also asking that the whole concept of agency be further kind of refined, and that the concept right now, agency includes acting at the direction, control, request, or being financed or subsidized in whole or large part by a foreign principal. In that definition of agency is the term request, right? And request can be something, as simple as a foreign principal asking you to help set up a meeting. No payment, they're just asking if you can do it. So the task force is asking that the word request be eliminated, because I think request is incredibly broad. And I think that has caused some consternation among, individuals who practice in the field, as well as individuals who engage in the type of activities covered in the statute. There's also talk about kind of reforming the LDA exemption, and that some things are more kind of simple and straightforward, that there shouldn't be any filing fees associated with filing under FARA, and right now there are fees. So those are the type of ideas that are being circulated amongst the task force. And there's also some legislative developments. Back in 2019, Senator Grassley introduced a bill to reform FARA. He just recently reintroduced that bill. It's pretty much identical. It's called the Foreign Agents Disclosure and Registration Enhancement Act of 2021. It's currently pending in committee. This bill makes the same suggested changes that were made a few years back, one of which is giving DOJ civil investigative demand authority to compel production of information associated with FARA inquiries. Right now, if DOJ wants a potential foreign agent to provide them with information, they can really just ask for it. There's no real subpoena authority or anything like that. They can bring an enforcement action, but there's no real way to compel information or compel a party to provide documentation other than DOJ just asking for it. So there is this proposal to provide civil investigative demand authority to compel the production of information associated with FARA inquiries. There's also a proposal in the Grassley bill to increase penalties for noncompliance. As Dan indicated, the current penalties are quite stiff, but they would become even higher if this bill moves forward. And for example, among the penalties include a failure to file a timely or complete supplement to a registration statement. That would be $1,000. Failure in general to file a timely or complete statement, if it's not a supplemental, would be $10,000. So these penalties can add up. Among the other changes in the bill is kind of requiring an audit of the Lobbying Disclosure Act exemption. As Dan mentioned, there's the 3 registration triggers. Once you hit those triggers, agency, foreign principal, covered activity, you have to register unless there's an exemption that applies. One of the most often used exemptions is the Lobbying Disclosure Act exemption. And that exemption is available if your foreign principal is not a foreign government or foreign political party, and the activity, your lobbying activity, is not principally benefiting a foreign government or foreign political party. Through the years, there's been a lot of complaints that exemption is often abused. You have parties that are engaged in lobbying activity that really should be registered under FARA, but instead they're availing themselves of the LDA exemption improperly. So the Grassley bill would require, they would not ask for the elimination of the exemption, but rather an audit, just to make sure that it's being properly used. So that kind of is there's a couple other proposals that haven't seen much movement. So I don't think I'll go into those right now. But there has been, as you can see, there's been quite a bit of proposals. Again, it's an old statute, so with anything, there's always room for improvement. I think FARA is an area where there definitely is room for improvement, given all the time that's passed by since its enactment.
So here's a legislative tea leaves question for either you, Tessa, or Dan, regarding the Grassley proposal. Do we know in this increasingly or absolutely polarized Congress, do we know if there's anything like bipartisan support for that? Do we know what the prospects are? Is it so far down on the legislative agenda that, it's not going to see the light of day? Do either of you have a sense of, I understand that's not a legal question as much as, it's just a kind of awareness question of the status of it. What do we think is going to happen with that, or is it too soon to tell?
With the disclaimer that my crystal ball has had some cracks in it from time to time. So predictions in regard to upcoming legislation, always a dubious proposition, but I think there's motivation on the Hill to do something. Is it necessarily reflected fully in the Grassley bill? I'm not 100% sure. And maybe it helps to take a step back. There are a lot of proposals out there, and I think there's been a lot of interest in Congress in regard to improving the Act. And as Tessa pointed out, the Act's been around for a long time, and there are certainly areas where it can be improved. And some parties have suggested that you need protecting the democratic process and the integrity of the democratic process. And I think a lot of reasonable people would agree that's a valuable objective. And especially when it has to do with potentially international or intentional foreign governments potentially covertly affecting U.S. government decisions or perceptions of the American public. I think there is common interest in wanting to see if that can be done better. On the other hand, I think there are significant concerns about chilling free speech. And that's also something that I think reasonable minds can agree that you don't want to unnecessarily or improperly regulate First Amendment protected activities. And FARA really is talking about inherently political speech, which is the core of the First Amendment. So I'm going to fudge a little bit with my answer, but I think there is room for agreement. I don't know if it's fully encapsulated in any one particular piece of legislation right now, But it does seem like there's a lot of interest. There are a lot of people talking about it and who are interested in finding a balance between not inadvertently chilling free speech, but making sure that the National Security Division of the Department of Justice has all the appropriate tools and authorities to enforce a law that is supposed to kind of protect the integrity of the democratic process. And there are people that are trying to find that middle ground. And I think what it looks like, and this isn't commenting on any one particular piece of legislation, but you can easily imagine that the middle ground is agreeing to a more narrow focus of the act in regard to potentially registrable activities, but then increasing the enforcement tools involving those specific activities. So, in other words, for a tighter focus, here's just kind of 2 points. As we've talked about, foreign principle under the Act isn't limited to just a foreign government or a foreign political party, but it can include foreign corporations and private non-US persons. And I think reasonable minds can have a debate about limiting this. And remember, FARA goes to the ultimate principle. So if you have a foreign corporation that's just acting as a shell for a foreign government, even if you tighten the focus to only cover kind of acts by foreign sovereigns, that type of indirect work in the United States would still be covered. So that's the idea of maybe limiting the type of foreign principle at stake. And similarly, right, and I think there's some real appetite for this, the Act covers 4 types of covered activities, one of which is inherently political activities. And I think rightfully that's a priority under the Act. But FARA also covers public relations activities. And while there are commercial exceptions for marketing, do we really think a non-US corporation that's involved in marketing or public relations activity, should that even be captured by the statute to begin with? Or statute also covers political consulting activities. So a US person providing kind of political advice to a foreign principal in the United States, is that the type of activity that we want regulated? Or just raising money for a foreign principal in the United States? So I think there are areas where the Act can have a more narrow focus so that it's really going after the type of activities that are of greatest concern, which are really foreign governments and foreign political parties involved inherently in attempting to change US foreign and domestic policy. But on the other hand, I think you can also give greater tools to DOJ. Reasonable minds can discuss what are the exact parameters for civil investigative demand authority. But while DOJ writ large obviously has subpoena power, the registration unit, the FARA registration unit itself is generally limited to letters of inquiry. The idea of having some power to compel documents, there could be value in that. Or the idea of making civil fines available so that it's not really an all or nothing approach, either no enforcement action or essentially going for a term of imprisonment. I think reasonable minds could find maybe a middle ground there. And there are other, potentially effective tools that could be provided to DOJ. But that is a very long way of coming around to your question to say that not exactly sure what piece of legislation is going to move, if any moves, but if I had to make a prediction, it would be something that has a compromise where it is a more narrow focus in regard to the type of foreign principles and the activities that they're involved in, but that ultimately provides DOJ with additional legal authorities and tools.
So I didn't see any cracks in that, but I guess time will tell. So Dan and Tessa, you've given us in this relatively short time kind of an overview of the history of FARA, the current status of FARA enforcement, some specific proposals for FARA reform, and then some kind of big picture policy considerations regarding what FARA does and what it should do generally. Tessa, do you have any last thoughts about FARA and enforcement and DOJ's role in enforcing FARA?
Sure. I guess I would end by saying, there's a lot of proposals out there how to help with the administration of enforcement of the statute. But DOJ, the unit that runs and administers the statute, the fair registration unit, they're already doing some of the things that are being recommended. For example, there's a proposal in the ABA report about, making the decision, their advisory opinion decisions even more transparent by minimizing some of the redactions in the opinions. But, DOJ, I mean, they have definitely increased the amount of advisory opinions that they're posting online so that parties can kind of get a sense of the fact patterns that may require registration or the fact patterns where an exemption may apply. So I think DOJ is really proactively trying to kind of maybe address some of the different, issues or different ways to, improve the administration of enforcement. And I'm seeing that with transparency. I'm seeing that with the volume of opinions that they're posting. They're issuing more guidance. For example, at the end of last year, they issued, I thought, pretty robust guidance on how DOJ views agency under the statute. So that was, I think, something that was very welcome for practitioners, just getting a better sense of how does DOJ view agency, because agency is so broad under the statute. Some of the things they've also clarified in their recent advisory opinions, for example, the concept of what is a political consultant. In one recent opinion that was just published, a redacted opinion, DOJ clarified that just, the definition of political consulting of the statute is quite broad, but the DOJ clarified, and kind of Dan indicated this, they're really focused on political activity. And they made clear in their opinion, they said that, as reflected in legislative intent of the statute, a political consultant would not be required to register as an agent unless he was engaged or she was engaged in political activities. I guess I'm already seeing a lot of positive, movement in terms of trying to ensure that things are as transparent as possible, not only just on, on the foreign agents end, but also on DOJ's end, to make sure that, interested parties are aware of what they view as registrable activity, what is the scope of exemptions. And I think, I know at least from Dan and our end, it's very much appreciated.
Well, thank you, Dan Pickard and Tessa Capeloto, Wiley Partners, for this FARA overview and update. And thanks to our listeners for joining us today on this Wiley Political Law podcast. See you next time. Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create, and receipt does not establish, an attorney-client relationship.